Thank you for joining us for part 3 of Return to Campus Considerations, the recorded webinar, or as we like to call it, podcast, series from the Higher Education and Healthcare Regulatory Practice Groups at Husch Blackwell. I'm Mary DeWeese, and I'm recording this podcast from Chicago with my colleague Ragini Acharya, who is based in our Denver office.
Return to Campus Considerations addresses legal issues facing institutions of higher education this fall in light of the COVID-19 pandemic. And today we'll be talking about how managing COVID on campus, which includes measures such as reporting to health departments, engaging in contact tracing, and advising the campus community, implicates various privacy laws.
So we've done these 2 episodes of our Return to Campus Consideration series so far, the first on contact tracing and campus testing programs, and the second on accommodation requests related to COVID. And now we're well into the fall semester. In fact, many schools are starting to wrap up their semesters. And across the country, it looks like positive case numbers are going up, including in states that maybe weren't hit as hard by the pandemic in the spring or summer. A concern that many colleges and universities have had to deal with is how to navigate the reporting of their positive cases, not only to the proper public health officials, but also to the campus community broadly, to students and faculty who might have been exposed, and so on. So our topic today, privacy concerns related to COVID-19, should be helpful both to those institutions who have already developed robust policies and procedures and are looking to refresh or revise them, and to those institutions that maybe have been really fortunate to not have had many positive cases yet, but are watching the news, seeing the numbers go up, and thinking about what measures they'll need to take in the event COVID hits their campus, either as this semester is coming to a close or planning ahead for next semester.
Right. So there have been no national standardized reporting protocols for coronavirus cases at IHE so far. So keeping track of on-campus outbreaks has largely been left to schools, which leads many institutions to wonder, when they're making decisions about the protection of data versus the disclosure of data, where do they even start drafting policies that appropriately balance protections of students' privacy with providing the public with important updates? And we know there are many health rationales that support an IHE's desire to disclose as much information as possible about COVID-19 cases on their campuses. And there are many privacy concerns that support a desire to keep public disclosure limited. In balancing these considerations, IHEs need to ensure they're acting within the bounds of federal and state laws that protect student and employee privacy.
So when I think about student privacy, the first law that comes to mind is FERPA, which applies to most post-secondary institutions. And I've heard from universities who are navigating how to properly employ contact tracing and public health reporting without violating FERPA. I'm going to turn it over to Ragini to talk about how these measures can and should be done in a FERPA-compliant manner. But first, I want to give a brief refresher on FERPA and why it's even a factor when talking about a student's COVID-19 test result. As I'm sure our listeners are well aware, FERPA mandates that an educational institution has written permission from a student, or if they're under 18, their parent, before releasing the student's education record or any personally identifiable information, or PII, from that education record. Now, education records are defined by FERPA as those that 1, directly relate to the student, and 2, are maintained by the university or by a party acting for the university. And this does not just include information like a student's grades. Certain health records, such as the immunization records that students may be required to provide when they register for classes, are education records under FERPA. Now, specific to post-secondary institutions only, meaning this provision of FERPA does not apply in the K-12 setting, FERPA contains a separate definition for certain records that are known as treatment records. Treatment records are those records that are made, maintained, or used only in connection with the treatment of a student and are disclosed only to the individuals providing the treatment. If the records are used for any other purpose or disclosed to someone who isn't providing treatment, then FERPA requires that they be treated as education records and subject to all the protections for education records. So as an example, a student's medical record with campus health might be considered only a treatment record by FERPA rather than an education record. But if that medical record is shared for non-treatment purposes, it would become an education record. And since positive COVID-19 test results are not only disclosed for treatment purposes, but are used for contact tracing on campus, etc., the records are likely to be considered education records under FERPA. But in either event, that is, whether we're talking about a student's record that's considered a treatment record by FERPA or is considered an education record by FERPA, most information that the school maintains about a student can't, as a general matter, be shared unless either the student consents or one of FERPA's exceptions applies. So, how can a university disclose information about a student's COVID-19 status without that student's consent?
So FERPA allows schools to disclose personally identifiable information from education records without consent to certain parties under certain conditions, including disclosure to appropriate officials in cases of health and safety emergencies. Under FERPA rules, as well as the Department of Education's guidance on FERPA and COVID-19, which was issued back in March of 2020, an IHE can disclose PII, or personally identifiable information, from an education record to appropriate public health officials without the student's consent if the IHE determines that based on the totality of the circumstances, there is an articulable and significant threat to the health or safety of students, faculty, or staff at the IHE, and disclosure is necessary to address that threat.
So as a general matter then, can the names and other PII of students who have tested positive be given to public health officials without violating FERPA?
Well, there isn't a one-size-fits-all answer to that question, but the answer is likely yes. Under the, quote, like health or safety emergency exception, the university must have a rational basis for determining that there is a health or safety threat, and the determination of the emergency cannot be based on a generalized or distant threat of a possible or eventual emergency for which the likelihood of occurrence is unknown. Given the department's guidance and what we know about how contagious COVID-19 is and the threat it poses, and the need for public health officials to conduct contact tracing and track cases, it is quite likely that disclosure would fall within that exception. But disclosure can't be made to just anybody. Typically, law enforcement officials, public health officials, and trained medical personnel are the types of appropriate parties to whom PII from education records may be disclosed under this FERPA exception.
So what about disclosure to others who aren't in law enforcement or health then? For example, if a school learns that a student has COVID-19, can it disclose that information to other students on campus? Can faculty be notified that they have a student who tested positive in their class? Or can the school publicly report on the total number of positive cases on campus without giving any names?
So it depends. Generally, yes, but only if that information is in a non-personally identifiable form. Specifically, the institution must make a reasonable determination that a student's identity is not personally identifiable, whether through single or multiple releases, and taking into account other reasonably available information. Further, the IHE should disclose only in a manner that does not disclose other information that, alone or in combination, would allow a reasonable person to make a determination as to the identity of the student. So, for example, to use contact tracing on campus, persons who had close contact with a student who is positive for COVID-19 will have to be notified of their need to isolate or quarantine. If there hasn't been consent to disclose, any information provided to other faculty, staff, or students pursuant to contact tracing should not specifically identify the student who is ill. And in most situations, simply disclosing non-personally identifiable information, such as total numbers of positive cases, generally does not invoke FERPA.
And you might have mentioned this earlier, but I think it's important to restate. Any surveillance testing program should provide notice to students that positive cases will be reported to public health authorities. Students could be asked to sign consent forms that agree to this limited disclosure for that limited purpose. While the exception we talked about can be used if consent is not given by students, given that many institutions of higher ed, which we're referring to as IHEs, are concerned about respecting students' privacy, those IHEs asking for consent from all students related to disclosure to public health officials and contact tracing protocols could be a reasonable protocol to consider adding to your institution's COVID-19 policies and procedures. So what about other laws, like laws that are applicable to faculty and staff? For example, when I think privacy, I also think of HIPAA, So how does HIPAA fit into the context of universities and their disclosure of personal health information during this pandemic?
That's a great question. So HIPAA, which is the Health Insurance Portability and Accountability Act, is a federal health privacy law and rule. Like FERPA, HIPAA protects personally identifiable information. Under HIPAA, protected health information, or PHI, is any information that identifies the past, present, or future physical or mental health of an individual. Identifying information that could reasonably identify the patient is protected from unauthorized disclosure. HIPAA explicitly applies to only covered entities, which are defined as health plans, healthcare clearinghouses, and healthcare providers who electronically transmit health information in connection with certain transactions, such as billing a health insurance plan. University-affiliated hospitals that provide healthcare to a general public are HIPAA-covered entities, but campus health clinics may or may not be. Your university council should be well aware, however, if you are a HIPAA-covered entity. One thing to note, however, is that even if an IHE is a covered entity, the records of students at campus health likely are not subject to HIPAA. In most college health settings, HIPAA applies only to the medical records of non-students, for example, faculty or staff. Since HIPAA specifically contemplates the protection of education and treatment records of students through FERPA rather than HIPAA. There may be settings such as, a university-affiliated clinic that is under the umbrella of a larger health system in which students' medical records are not FERPA education records or treatment records, and thus HIPAA would apply. And this carve-out does not apply to the records of non-students. If faculty could see a physician at campus health, for example, that faculty's medical records may be PHI under HIPAA. So what university administrators would need to know is that certain universities may be subject to both HIPAA and FERPA in different ways.
So what do those universities that are subject to HIPAA need to know when thinking about the disclosure of information through contact tracing, public health reporting, and other COVID-19 related measures?
So yeah, we talked about FERPA's health or safety emergency exception. HIPAA has a similar but not identical exception. HIPAA permits the disclosure of PHI without authorization to various law enforcement officials, medical personnel such as first responders, and public health authorities when such disclosure is required in order to prevent or control spread of disease, or when it's necessary to prevent or lessen a serious or imminent threat to the health and safety of a person or the public.
So if an IHE has a surveillance testing program and learns of a positive case, can they notify public health authorities under this exception? Can they notify other students? Can the university tell a student's parents that they've gotten COVID?
Right. So reporting COVID cases to public health authorities almost certainly falls within this exception. Contact tracing, as an important tool to mitigate the spread of disease, likely does as well. However, HIPAA may not even be applicable to the scenario you described. As we talked about, the university may not even be a covered entity under HIPAA, and even if it is, it might be what is called a hybrid entity. So whether the university's contact tracing program falls within the HIPAA-covered healthcare component of the university system or outside that component is going to be pretty fact-specific. But assuming HIPAA does apply, if the university is disclosing PHI in a contact tracing program, the university must take reasonable efforts to limit the information used or disclosed to that which is minimum necessary, like the least amount possible. As we talked about with FERPA, this really means that a student or employee's name should not be provided during contact tracing, and care should be taken to not provide so much information that identity of the individual can be easily determined.
So here's something that universities may be dealing with, and as we're talking about, I understand that FERPA really is applying to the students, and HIPAA may or may not apply to students and may or may not apply to faculty depending on the facts of the case. But in a HIPAA covered university, if a student has COVID, can the university tell that student's parents? Many university and college personnel are familiar with parents calling the school and asking for information about their child, like their grades or their classes, only to become really frustrated that the school won't disclose that information, citing FERPA. It's a change for a lot of parents from having their kids in the K-12 setting and being under 18, where the FERPA rights really, the parent has a lot of rights under FERPA, and once the student is over 18, the FERPA rights are theirs and theirs alone. So I'm sure there are many parents concerned about student health and safety during this pandemic, and they want information about their children. What can the university give them?
Well, as you've identified, once a student is 18, their parents don't really have any rights to their education records under FERPA. This consideration doesn't change much when considering COVID-specific PII from an education record under FERPA or PHI from a medical record under HIPAA. However, there's a specific exception in HIPAA that permits disclosure without written authorization to family and friends involved in a person's care. This exception is limited. It applies only where the patient has given verbal permission or the entity can either reasonably infer that there is no objection, or the patient is incapacitated, or it's in the patient's best interest that their PHI be disclosed to those families or friends involved in their care. This exception really should not arise for universities. In the event that a student or employee is gravely ill with COVID, the hospital personnel will be the ones making decisions about whether disclosure is permitted under HIPAA.
What about campus-wide reporting or reporting to the broader public?
So the affirmative reporting to the media or the public at large about an identifiable patient, or the disclosure to the public or media of specific information about treatment of an identifiable patient may not be done without the patient's written authorization. But advising the campus community about the number of cases on campus without providing any names or identifying details, that shouldn't run afoul of HIPAA or FERPA in most cases. Okay, so we've talked about the two big privacy laws, FERPA and HIPAA, but are there other laws that provide privacy protections relevant to COVID on campus?
The ADA, which we talked about in our last episode, should also be top of mind for college administrators who are making disclosure decisions or developing plans that involve disclosure, such as testing programs and contact tracing programs. The Americans with Disabilities Act requires employers to keep confidential any medical information they learn about any applicant or employee, even if that information is not about a disability. And medical information includes not only a diagnosis or treatment, but also the fact that the individual has requested or is receiving a reasonable accommodation. The ADA also requires that medical information about a particular employee be stored separately from the employee's personnel file, thus limiting access to this confidential medical information. So information that an employee has symptoms of or a diagnosis of COVID-19 is medical information. However, the fact that it is medical information does not prevent an IHE from reporting to the appropriate officials so that they can take actions consistent with guidance from the CDC and other public health authorities.
So what would happen if other faculty and staff hear that they've been exposed and want to know from whom they've received that exposure? Like, what if a supervisor learns of an employee's COVID status and wants to tell others for purposes of covering that employee's shift or advising that, personally protective equipment be used when cleaning that employee's workstation?
Well, the university should make every effort to limit the number of people who are told that an employee has COVID. If an employee is designated as needing to know the identity of the employee, they should be specifically instructed that they must maintain the confidentiality of that information. And the number of persons who truly need to know is generally pretty limited. That said, it's not an ADA violation to notify others that they've come into contact with an employee, an unnamed employee who has tested positive for COVID, provided that they're giving this information without revealing the employee's identity. Now, other employees might get upset when they're told that they might have been exposed and the university won't tell them which of their coworkers tested positive, but the law is pretty clear on the confidentiality obligation.
Okay, yeah, that makes a lot of sense. And it always helps to reiterate that IHE should really make sure to look into state-specific laws on personnel records and any specific laws under state data privacy laws. Any plan to disclose or not to disclose information about COVID on campus should be run by legal counsel, and they can help provide more specific advice on the full scope of applicable legal obligations. Given all these legal considerations, what should institutions of higher education keep in mind regarding privacy concerns in the context of contact tracing?
So contact tracing, as we've discussed, can be a powerful tool in helping stem the flow of cases and the spread of the disease. Some universities are handling this in-house, whereas others rely on the local health department to help them with contact tracing. So whether you have a robust contact tracing program on campus right now or not, you should be reporting to public health or the appropriate public health agencies and authorities that you have positive cases of COVID on campus, whether it's student, faculty, or staff. And in fact, the CDC encourages all employers to collaborate with health departments when investigating workplace exposures to COVID. It also cannot be reiterated enough how important it is to write and publish written policies and procedures to address and limit the scope of disclosures. Both in the context of defining who will have access to the personal health information of students and faculty and staff, and in terms of how much information will be shared and how information will be kept confidential. With respect to testing programs, you should advise students and employees of how and with whom their personally identifiable information will be shared if they test positive for COVID. And of course, your policies and practices need to be legally compliant. You should consider having written waivers authorizing limited disclosures, for the purposes of reporting to public health and engaging in contact tracing, as part of your on-campus, surveillance testing program if you have one. That said, a one-time waiver that, in theory you want to be applicable to all future tests might not be sufficient under FERPA or HIPAA. So, just something to think through if you're going to have a testing policy or a contact tracing policy that has waivers, to think through the legal impact of those waivers and whether they can be relied upon. And when you're doing contact tracing, reasonable efforts need to be taken to not give information about a positive case that would disclose that person's identity. But this should be balanced with the need to give enough information so that you can, alert somebody that they've been exposed. So there should be written policies that detail who is responsible for receiving information about a student's or employee's COVID status, what next steps are required, how and whether disclosures will be made, and how, like I said before, how confidential information will be protected. And of course, the last thing I really wanted to mention is that any contact tracing apps that you might be using certainly raise privacy concerns as well. With regard to who can access the data, what sort of protections are in place on those applications to make sure that there's no data breaches. While this is beyond the scope of our discussion today, it's something that universities need to concern themselves with.
Yeah, that makes a lot of sense. And we also wanted to quickly mention that our colleagues Teresa Molyneux and Demetrius Peterson discussed various privacy concerns that institutions of higher education may face, including the potential for overreach and uncertainty of who will have access to health information in their webinar, Student Health on Campus, which was published on September 21st. And we've included a link to that webinar in our slides here. We want to thank everyone for joining us today and let them know that we have one more series podcast coming up in a couple weeks. We hope everyone has a safe and healthy holiday season, and please feel free to reach out to either Mary or myself if you have any questions. We've included our contact information on this last slide.